Madam Chairman, members of the committee, Todd Vandermyde, on behalf of the National Rifle Association, again, I want to thank you for this opportunity to present some rebuttal testimony and talk about a couple of things I've heard. This morning, as Representative Durkin alluded to, the Seventh Circuit Court of Appeals turned down the en banc request from the Attorney General. And in the opinion at the bottom of page 5, it states very clearly, the panel majority opinion is now the law of the circuit, and Illinois has 180 days to decide how to amend its laws. I think earlier in the week there was some question about whether or not the federal courts had jurisdiction over this matter, and I would submit to you that they do. And there was even a 2000 Illinois State Supreme Court case of the People versus Nance that quite specifically pointed out that the remedies in the federal courts, if the state doesn't like the answer, and that the state courts were not going to be used as a Ponzi or a ping pong ball in this. With that, I think what struck me the most today was when I heard Chairman Preckwinkle sit there and talk about a privilege. And that's the problem with the majority of the people who don't like the bill that the legislature is charged with crafting. They continue to want to ignore Heller, they want to ignore McDonald, they want to ignore Ezell, Moore, Shepard, Lawson, Gowder. This is a fundamental, constitutionally protected civil right. The right to self-defense, the right to own a firearm. It's not a privilege to be meted out by bureaucratic people on an eeny, meeny, miny, mo. If that's what certain people want, then I don't think that Bull Connor was doing that with the civil rights back in the day. That's not the way the Second Amendment is to be treated. It's to be respected like the First, the Fourth, the Fifth. I'm sure that, as the superintendent testified to, that the, some of the restrictions, because it is a fundamental right, are, detrimental to some policing attitudes. But I guess probable cause and having to obtain a warrant are hurtful of some policing attitudes as well. Or maybe we'd like to go back to the days of John Burgess to how we got confessions out of people. Dealing with a lot of things that are in the bill, private businesses can post. That includes hospitals, that includes restaurants. Any private business can post that they don't want people carrying into their establishment. And what I've heard is, you had the Restaurant Association here sit there and say that, well, we want it statewide. There are restaurants in this state that don't want to do that. Not only that, there are national chains that have national policies. Some say we don't like people carrying guns. Some say we'll live under whatever the rule of the state is. If they say no, it's no. If they say it's okay, it's okay. There are national hardware stores and other places like that that have similar policies. But what the opponents of this legislation have consistently tried to do is now say, let's pass a law that looks like a carry law, but is now a regulatory ban, that we keep saying you can't carry here, you can't carry here, you can't carry. And by the time you're done drawing all those circles, you'll be lucky to walk down the sidewalk. But we passed a law to comply with the court decision. And that's not the spirit of the law, nor it is what we intend to work on. Local law enforcement that we've dealt with does not want to administer this. They want a uniform, statewide permit. At least with the FOID card, they recognize that it's issued by one agency, the Illinois Sheriff's Association, who we've negotiated with for over 4 years. They do not want to be the administrators of this law. They want to have it go to the state police. The Chiefs Association is in the last contact we had with them are in the same position. And this would then create an unfunded mandate on those local agencies, which we're always hearing about unfunded mandates on business. There's training required in the bill. The enumerated commercial courses generally run between 8 and 10 hours and sometimes may go a little bit longer depending on how the instructor runs the course. Along with that, you have to pass a range qualification. We plan on introducing an amendment to change the range qualification based on input from law enforcement who has reviewed the past language and said we think there's a better way to do this.
30 seconds, Mr. Vandermyde.
Okay, this is going to be tough, madam, because there's been a lot of people up here saying a lot of things.
And this is your second opportunity to testify.
There were only 4 of us. With that, duty to inform. Duty to inform a law enforcement officer is in the bill. If you are caught, if you're pulled over, and the minute that individual asks you for an identification on an investigatory or Terry stop, you are obligated to tell the officer you are in fact carrying a firearm. Now, whether it's oral, whether you hand them your license, and in a lot of states, there's a duty to inform. The penalties on that vary from a traffic ticket to something more than that. With it, I heard the exchanges between the superintendent and other members of the committee about what are cops supposed to do? Again, cops in every other major metropolitan area do this. I just don't believe that Chicago police officers are trained at that substandard of a level that it's a problem. And I'll be happy, I'll close with this. You guys are about to engage in a debate over gay marriage. It's amazing that we can rocket that piece of legislation through to codify or expand a form of equal protection under the Constitution. But, and certain members of the body think that everybody south of I-80 is some kind of Neanderthal that has to get their mind right on that issue.
Okay.
But now, when it comes to having two appellate court decisions,
Mr. Vandermyde,
two
you're over a
Supreme Court
minute over,
decisions,
so you can talk a little bit more about gay marriage, or you can get to your point and finish.
I think some other people who don't like this issue ought to get their minds wrapped around that the Second Amendment is a fundamental, constitutional, protected civil right. I'll answer any questions you have.
Thank you, I appreciate it. Questions from members? Representative Drury.
Thank you, Madam Chair. Thank you, Mr. Vandermyde, for your comments. You're a reasonable person, right?
I think so.
Okay.
I ask my wife some nights, I don't know.
I mean, and is it fair to us, you talk about civil rights, I mean, and constitutional rights, right? People also have a right to life, liberty, and the pursuit of happiness, correct?
Yes.
And I assume that the NRA's position is the NRA does not want innocent people, some of these family members' children, doesn't want innocent people to die. Is that fair?
Correct.
And if there are steps that can be taken that we as a panel can take that can protect innocent lives, I assume you would agree that those steps should be taken.
It depends on what type of infringement on a fundamental right you want to get to that point.
Okay, so I just want to make sure I understand what you're saying here. So if there's steps we can take to protect innocent lives, there may be things you don't want us to do that.
I think that your interpretation of how you think you're going to protect somebody versus what actually works in practicality are probably going to be a difference of opinion.
Okay, my question was simpler, sir. My question was, if there's steps that we can take that will protect innocent lives, would you agree that we should take those steps?
Depending on how they infringe on a fundamental constitutional right. I'm going to disagree with your premise.
Okay, so your answer is no, we should not take certain steps to save innocent lives.
Would it help people if we did it away with the Fourth Amendment and the requirement for search warrants?
Sir, I'm asking simple questions, and I'm just trying to get answers to understand what you're saying.
I'd ask the ladies and gentlemen in the audience to refrain from making comments about the questions. The representative has a right to ask his questions.
I assume, sir, that you, me, and the people in this room, we don't want deranged, psychotic people running around with guns. Is that fair to say?
Correct.
And when they do, when that situation happens, when they end up at a school, at a movie theater, it actually makes the position that you're promoting harder to promote, right? Because you have these people that have mental health disabilities or mental health issues that get access to guns, and it hurts your cause, doesn't it?
Any criminal that misuses a firearm, they try to use and reflect on the average gun owner. Yes.
Right. And you're aware, I'm sure, that the Auditor General back in April of 2012, he issued a very lengthy report talking about the FOID card system, correct?
I drafted that resolution to ask for the audit.
Okay, it was the Firearms Owner Identification Card audit, correct?
Yep.
That's what the FOID card is. And in that report, the Auditor General found that in Illinois, out of the 102 counties in Illinois that are supposed to report mental health disorders to the ISP, the Illinois State Police, only 3 of them were doing that. Is that right?
That's what the Auditor General found, but I think there was some discrepancy with the state police on that audit.
Okay, but the Auditor General's report, which has been published, found that only 3 out of 102 actually were reporting, correct?
That's what he wrote, yes.
Okay, and of those 3 counties that were reporting, he found that almost half of those reports were inaccurate or incomplete. Correct?
I believe so.
Okay, so we have 3 counties that are reporting, and half of their reports are actually inaccurate or incomplete. Is that right?
I believe that's what he wrote in his report.
And that only 30% of firearm owner identification cards that I, as a prosecutor, worked hard sometimes when we prosecute people, they're supposed to take those cards away. Only 30% of those cards that are supposed to be taken away are actually being taken away. That's what the Auditor General found, correct?
Yeah, I believe the district attorneys and the ASAs across the state and the judges are failing the people of Illinois repeatedly.
I appreciate your opinion, but what they found was only 30% of those FOID cards are being taken away, correct?
I think so, yes. I haven't read the report in about 6 months.
Okay. And his conclusion was that he found that the FOID program is limited in protecting the public safety.
Yes?
And he also found, well, the FOID card doesn't just go to Illinois databases. It's actually reported to NICS, right, which is the federal database maintained by the Federal Bureau of Investigation.
I don't know about how they interconnected to Representative.
Okay, well, I can read to you what the Auditor General said, and you can tell me if you agree or disagree. He said that in addition, because many of these disqualifying conditions are also required to be reported to the Federal Bureau of Investigation's National Instant Criminal Background Check System, which is used by other states when individuals purchase firearms, the safety of the general public as a whole is at risk. That's what he found, correct?
If that's what he wrote.
Okay, so Illinois' lack of ability to enforce its FOID card program not only is endangering people in Illinois, but we're endangering people throughout the rest of the country, according to the Auditor General, correct?
If that's your conclusion, Representative, I don't know.
It's not a conclusion. I'm asking you a question, sir.
Asked and answered. If that's what the Auditor General wrote, that's what he wrote.
Okay. And this bill that you say that people are trying to get around, this bill doesn't have any waiting period in it before a license is issued to allow the Illinois State Police and the county clerks and the state of Illinois to get its system in gear in order to be able to correct all of these problems that the Auditor General has found.
Oh, no. We're going to implement a law by June 9th.
Right. So this bill, despite all of these infirmities that we've just gone through, this bill does not allow anyone to have a waiting period to fix the known problems with the system before someone can go purchase a concealed or apply for and receive a concealed carry permit, correct?
If you're saying that should there be a delay until the system is perfect before we even enter into, doing what the court said, there is no delay in the implementation of this. If that's what you're asking, there is no, they've got 9 months to get a system up. We had that argument 2 years ago. You weren't here for it. But we had that argument, and we asked everybody then, here, let's do this. We put forward the resolution on the audit of the FOID system because I'm one of the guys that gets the complaints daily about people who can't get their FOID cards processed because they're in that 70,000 person backlog. And over the last couple of years, either the governor has refused to fund that part of the agency at the appropriate level. We even asked for supplemental authority language in the last bill you guys voted on a couple weeks ago to help get this process up and running. And the governor's office refused to submit it to the legislature. So I can't be responsible, nor our organization, for the financial mismanagement of the state by the governor of the state of Illinois. Nor can we be required. I can't make the circuit clerks do their job. That's a function of government. I'm not the king of Illinois. I'm a lobbyist. I can ask to help write laws to make it better. We supported laws and making more reporting on mental health issues. But if the clerks of the courts, the assistant state's attorneys, and the governor of this state aren't going to do their jobs, please tell me how you expect me to fix that.
Sir.
Ladies and gentlemen, no more demonstrations.
Sir, my microphone's working, correct? So you hear the questions that I'm asking?
Oh, I heard it.
Okay, so when I ask a question, I'd appreciate the courtesy if we could just answer the questions. Okay? Thank you. Now, my question is simple. Is the NRA willing to wait for the Illinois State Police and the county clerks to make a statement that they are prepared to handle the applications coming in and enforce the laws, and that they have a system in place that can adequately deal with the issues that the Auditor General found before any implementation of a concealed carry law goes into place?
It's not up to us. The Seventh Circuit has put the timeline in place.
Is the NRA willing to wait?
If you think that we should wait one more day so we can have another Mary Shepard, if you think we should wait another day to have another victim.
Sir, is the NRA willing to wait? It's a yes or no question.
We want the law implemented in the court's timeline.
So the NRA is not willing to wait?
We're going to ask that the court enjoin the state if we don't have a law by June 9th.
And I'm saying if you have a law, and in the law it says that we need to wait to issue a permit until the proper procedures are in place to make sure that we're not only protecting the citizens of Illinois, but of the whole country, is
the application, because we're not representative. If you want to
Sir, then I'm going to take your lack of an answer as a no. Unless you want to dispute that, I'm going to take your lack of an answer as a no. The NRA is not willing to wait to protect the lives of Illinois and lives of the people of the United States.
We think that everybody ought to be protected, including the Mary Shepards of the world.
Thank you.
Thank you. Representative Rebeletti.
I find that a very interesting line of cross-examination, but I think each witness should be treated with the same respect, and I respect the ability of any representative to ask the questions the way they'd like to. But I was looking at a document, and this is not a question, Mr. Vandermyde, but from the Illinois Association of Court Clerks. Because I talked to my circuit clerk, Chris Katch-Rubis, who represents the second largest county, as to why they were not in compliance. One, I asked him if he was in compliance. Number two, I asked him if he's not in compliance, why. And if you look on page 2, 99 counties believe that they don't have the ability to forward the information because it's at the direction of the court, of the judge. And I've talked to Chairman Nekritz about making sure any legislation that we pass regarding this issue has that. I don't think any of us here don't want the circuit clerks of this state not to report any valuable information in taking away firearms from people who are mentally ill, who are convicted felons or misdemeanors, if we exclude those people. So I want to make sure that that's part of this record, and I'm sure at some point the county circuit clerks will, I know that Chairman Nekritz has told me that they will have a chance to testify. I think that's important to do, that it's not that 99 circuit clerks aren't doing their job, because obviously if they weren't, we could have the Attorney General file a writ of mandamus to ask them and require them to do their job. But that being said, I have a couple of questions for you, Mr. Vandermyde, regarding one being lost and stolen. And I've had this conversation with the superintendent, with others, and can you give me your thoughts on the lost and stolen issue, is why you don't support lost and stolen?
First off, we think that it simply tees up a law-abiding gun owner in a gotcha situation. And as I alluded in the last time I was before the committee about an individual who tried to do the right thing but still had 4 CPD officers knocking on his door because his local police department would not take the report. Along with that, the bill the superintendent is promoting isn't just lost or stolen, it's any transfer. That's a registration system of every firearm in the state every time it moves. We have never supported it. We never will. Let's remember that it was a registration system that led to Chicago's handgun ban because they closed it down. And for 30 years we lived under a handgun ban until the Supreme Court said otherwise. Every time we've seen registration systems used, they've been abused. New York sat there and said, oh, you have to register your firearms. Then all of a sudden they enacted a new ban and all those individuals got notices, surrender your guns, move them out of state, or weld them up, make them permanently inoperable. Same thing happened in California. So it's not just lost or stolen. But in Maryland, we've seen a unique thing. There was one individual out in Maryland that every 9, 12 months would have a break-in. And 12 or 15 guns would be gone, and he'd file a police report. And then he was off the hook. He was actually fencing them. Which also brings into the question that, years ago, Dave Savini, an investigative reporter in Chicago, did an expose on the CPD. Found over 900 firearms were missing from their inventory. A couple of those firearms that were supposed to be in the evidence lockup ended up at crime scenes. The CPD has refused to this day to return over that report. It would be very interesting to see what their report actually detailed as to how a gun that is supposed to be in an evidence lockup ends up at a murder scene. The other part about lost or stolen, Representative, is just, like I said, it's a gotcha situation. And I don't see, and the bill also contains provisions to remove or revoke a fundamental constitutional right for failure to report a property crime. Now, what's the penalty for not reporting a rape in the state of Illinois? If somebody's not going to be criminally charged or held liable for a sexual assault that they failed to report, then how do you remove a fundamental constitutional right for failure to report a property crime?
Let me direct your attention also to straw purchasing, just briefly. I know that we partnered with the NRA and the City of Chicago to pass the straw purchaser bill, and I remember being interviewed and talking about the fact that we were actually able to put the NRA and the City of Chicago together, which usually have not seen eye to eye on a number of issues. What else do you think we can do to stem the tide of illegal firearms through straw purchasers, or what would you see that we could work through? I know that you've dealt with this issue quite a bit.
Well, yeah, working with you, we wrote the original Straw Purchase Act that's on the books. And what it is that a straw is when somebody goes in and intentionally lies on a 4473 with the intent to give that to somebody else. That's a crime in and of itself, and we made it a crime here in the state of Illinois, so we don't have to wait on the U.S. Attorney's Office, although under the federal guidelines, it's usually a 5-year mandatory minimum. So we dealt with that. The question is, how's it being prosecuted? Because if you get more than 3 straws and you can show that they've transferred the guns, that now transfers into gun running, which is a Class X. So you can pile on the charges on this stuff if you want to. But I think one of the things that we've been investigating, there's a federal statute on the books that says if you are a prohibited person and you direct somebody else to carry a firearm at your behalf, that's a felony. And I think that we can craft a law like that, because if the senior gang leaders think they're going to have the young ones or the shorties carry the gun because they're only going to go to juvie, they're only going to get 6 months, now we can sit there and throw another charge at them if the state's attorney's office is willing to follow through on it.
Thank you.
Representative Welch.
Thank you, Madam Chair. Good afternoon, Todd. I just have a couple of questions I've asked of other folk who have testified here this morning. I want to ask of you as well. We spoke in Springfield briefly and a couple of different times, and you know, everyone up here is a lawyer, and we've all taken an oath to uphold the Constitution, and we're here today because we're really trying to do our best to make sure we implement a law that is fair, reasonable, and constitutional. And we all respect the Second Amendment of the Constitution. My concern, as I said to you in Springfield, is, you know, I represent Maywood and Forest Park and those areas. And Forest Park, for instance, has a huge CTA train station that thousands of people go through every day, including a number of students. Is the NRA really not willing to compromise when it comes to the issue of mass transit?
Again, Representative, I think what happens is you have these people trying to draw out these large circles and create large no-carry zones.
I'm only dealing with mass transit.
We're very much inclined to keep that in the bill to the end. And we think that just because you avail yourselves of public transit, because of your economic status or the way your commute runs, that you should not be deprived of your right to self-defense.
Have you ever been to Forest Park, Illinois?
Yes, I've been through it. I took the train in today.
Through Forest Park?
Not today. Today I rode the Burlington Northern Line, but I've been through Forest Park.
And is it your position here today? The NRA is not willing to compromise on that particular issue with regard to firearms on mass transit?
Not at this point.
That leads me to believe that at some point you could be.
It's going to take a very big, our answer is no, it's something that needs to be in the bill. You know, sometimes you never say never, but I don't think that, I don't think it's a point we're going to move on.
I think it's fair to say you heard a lot of testimony here today, and we're deeply concerned about firearms on mass transit. The other issue that I wanted to ask your opinion on is with regard to law enforcement officers. Since we are the only state in the country that does not have concealed carry, I have to imagine that you have some idea how it's done in other states. What is a reasonable expectation of those who are lawfully carrying a firearm when they are encountering a law enforcement official?
The duty to inform language that is in the bill was the subject of negotiations between us, the sheriffs, and the Chiefs Association. Now, there are many people in my organization as members who don't like it. There's a very viral video of a bad encounter with a law enforcement officer who wouldn't let the motorist get 2 words out edgewise to let him tell, I have a firearm, I have a permit, despite him handing the permit. The video went viral. The officer was fired for his conduct. We made an agreement with those law enforcement groups. We think the duty to inform language that is in there is fair and reasonable for, I think the bigger question is...
We have a number of bills that we have to consider. Are you referring to which one, 997?
997.
Okay.
I think the other question is, what is the police training board going to do to update their training modules for law enforcement officers as to how they should be handling? Most cops I know tell me that if you don't approach every car as if there's a gun in it, you're asking for trouble. As a former military police officer, I understand that. By the same token, I think that there are some police officers in the state that are much more comfortable with people having guns, and in different states they react differently to it. Sometimes the cops say, where is it, don't touch it, don't make any sudden moves. Sometimes the officer may take custody of the firearm, although a lot of them don't want to be handling loaded guns if they don't have to be. Sometimes, they'll ask the guy to put it on the dash so they can keep an eye on it. I think the real question is, how are we going to make sure, it took us 4 years working with the sheriffs and with the chiefs to break through the mentality that it's been 60 years of no, this is not the way we operate. And I think now we have to get through that and look at some realistic situations. I know how I act when I'm in a vehicle, and if I'm pulled over, don't light goes on, hand stay on the steering wheel, no sudden moves. It's common sense. I think that when we come to the general training aspects as to how people react to law enforcement encounters, it's a two-way street. Law enforcement doesn't need to overreact, and the permittee doesn't need to be making, sudden or other moves that are going to give the officer a different theory. But one of the savvy old-timers I've talked to, I asked him, how do you tell the good guy from the bad guy? And he says, 9 times out of 10, the good guy's got a holster. The gangbangers generally aren't spending $100 on a Galco rig or anything else. They're sticking it in their pocket or whatever, trying to hold it up with their belt. That's good police work.
Thank you, Todd.
Representative Williams? No? Okay.
Thanks again, Todd. Just want to know if you could very briefly address the testimony of Superintendent McCarthy earlier about the training requirements. Like anything that you practice or have training for, some of us are better at things than others. I imagine for some people 8 hours might be sufficient. For some people they're never going to be able to safely handle a weapon. And how do we make that distinction in the training requirements?
Well, I think there's 2 things here, Representative. One is that there's not only the classroom portion of it, there's the range portion of it. And you're not going to be able to get the permit until the range officer signs off on the training requirement that, one, you qualified and you met the criteria there. So the range officer is going to have to feel comfortable putting his name on that certificate. It's the way it works in a lot of other states. And I see it working in a lot of other states. We haven't seen a single state make a concerted effort to repeal a carry law once it's been enacted. I don't think Illinois is going to be any different. Now, I recognize that when you start carrying a gun in public, it takes on a different connotation, but let's remember, in order to be able to use the use of deadly force in self-defense in one own's home on one own's land requires absolutely zero training. And so I think when you start talking about 8 hours, we're not cops. We're not there to, act as cops. It's not citizens arrest. It's none of that. You have a firearm on your person for the protection of yourself and somebody in your close proximity. Those rules are fairly well established.
Okay, thank you.
Representative Sims, quickly.
Yes, ma'am. Thank you, Madam Chair. Todd, I want to talk a little bit about the home rule preemption. Listening to President Preckwinkle and then Superintendent McCarthy, I think both would acknowledge that there are circumstances that are unique to Cook County and the Chicagoland area that may not present themselves in other areas. So being able to have the tools to manage the process for a Chicago or Cook County would make the implementation of the act more effective for them. In a previous conversation, I believe that you and I talked about your inability, or the NRA's inability, to give on the preemption issue. Having heard some of the testimony today, has that changed at all, or what's the NRA's position on the home rule preemption?
You're right. Chicago and Cook County are special. They are especially abusive to the rights of gun owners. And we don't think that giving them any more leeway or discretion is going to be helpful to that. Let me give you an example. Just a week ago, an individual who drove into the city to pick somebody up, take them out shooting, drove them back into the city, was pulled over for having a taillight out. Had an NRA sticker on the back window. Was asked by the Chicago law enforcement officer if he had any guns with him. And he said, yes, I just came from the range and dropping somebody off. There were 3 in the trunk: a rifle, a 9mm handgun, and a .38. He was detained, arrested, and taken in and charged under Chicago ordinance for having unregisterable guns. He's not a resident of the city. He's not obligated to have his guns. And when you see abuses like that...
But by the same token, Todd, for individuals who are residents of the city of Chicago or of Cook County, and they do not register their guns, they are obligated to do that, and there's nothing wrong with that. If the citizens of Cook County and their elected officials, or their citizens of the city of Chicago and their elected officials have determined that that's what's in their best interest, I don't understand why the NRA is unwilling to give on that issue.
The issue is that it's a fundamental constitutional right that's going to be enforced with one standard. We don't have different standards for search and seizure. We don't have different versions of the Fifth Amendment and your right to, remain silent. And this is a fundamental constitutional right, Representative.
But for every may issue state, that issue, the issue of whether or not the local law enforcement, be that local law enforcement, city or county, or the state law enforcement, has the ability to determine what is permissible. And again, I'm trying to understand how we're going to ultimately get to a place where this bill, this law, is going to work for everyone. And it seems like it's going to be a point of contention for all of us.
Yeah, I understand it, but let's think about a May issue bill under Rob Blagojevich. He'd have been asking $10,000 campaign checks for permits.
Well, Rob Blagojevich is no longer governor of the state of Illinois, so I mean, I don't want to talk in hypotheticals here. I'm talking about, as Superintendent McCarthy sat there at that table and said, we've had 3,500 guns that have been stolen. In my district, and I would imagine that many of the districts of members who are from the Chicagoland area, they've had child and student after student and person after person who've been the victim of gun violence. So we are trying to get to a point where we respect the Second Amendment. I think Representative Welch said it very, very well. We all respect the constitutional rights and fundamental rights, but it's at the end of the day, it's also about the Constitution of the state of Illinois that says we are charged with protecting the public health and safety, and I think that's the discussion we need to be having also.
I understand that. The question becomes, how do you sit there and tell Otis McDonald he's a second-class citizen because he lives within the city of Chicago? You just heard the superintendent, if my ears were right, testify that it wasn't people with FOID cards that he was picking up that were the problem. And I don't think it's going to be people with carry permits that you pick up that are shooting out street lights or doing other things, because we're not the problem.
Well, again, I would agree with that. And if the point is we are trying to get to illegal gun use, then I don't understand why the NRA. I don't understand the NRA's opposition to the preemption anyway.
What business does the superintendent of the city of Chicago need deciding who gets to exercise their rights or not?
It's not about the exercising of the rights. It is about. Thank you all. I appreciate that. But at the end of the day, it is about making sure that we have laws that are in the best interest of the public. That's the bottom line.
I'll agree with you on that, Representative, but it's a fundamental right. You either get the right or you don't. Maybe the people in Englewood, in Representative Tepetti's district, shouldn't have the right to remain silent. Maybe we should do away with, and give them warrantless searches in those areas. It's a right or it's not. That's how we view it. We think it's a right that deserves a single uniform standard across the state. No, whether you're from Cairo or Chicago or from Moline to Lansing. It's a fundamental right. That's the position we come from. That's what the Court of Appeals said. They said it's a fundamental right. And all that does is to say, okay, Chicago, you can have your own permitting system. We've seen how abusive they've been to this point already after McDonald. Now, to just give you a point, remember under the Chicago ordinance, you can't take your handgun or other firearm outside the four corners of your home and be in compliance with the ordinance. You can't go to your front porch. You can't go to your detached garage. Now they've got to amend their ordinance because the Seventh Circuit Court of Appeals just said something different. But that's how abusive the city is. And since they haven't been shown to be good actors or good faith participants with what the court is, if I remember correctly, Justice Rovner said they have thumbed the municipal nose at the Supreme Court. We're not going to give them that chance again.
Thank you, Madam Chair.
Thank you. I think we have no one else seeking recognition, so I think we've appreciate everybody's participation here today. I would announce that the next subject matter hearing on the issue of firearms will be this Thursday, February 28th, in Springfield at 9 a.m., and the subject matter will be assault weapons. So that will be the next hearing.
Thank you, Madam Chairman, for your indulgence.
Thank you all very much, and the Judiciary Committee shall be adjourned.